one of the questions I get is I often represent juveniles, and those are individuals that have been arrested or being investigated for a crime that are under 18 years of age. And we often, what is heard on TV, that your Fifth Amendment constitutional rights, or otherwise known as your Miranda rights. Well, do Miranda rights need to be read to kids or juveniles when they've been arrested or under investigation, meaning kids anywhere 12 to 17 or even younger, surprisingly? The answer is absolutely yes. What oftentimes happens is that a parent will come to me and they've allowed their son or daughter, their juvenile son or daughter, to be interviewed by law enforcement, and they've given permission to allow them to interview their son or daughter. Highly, highly recommend against doing that. And I know that sounds counterintuitive because I think we're all taught, or most of us are taught, that when you're a law-abiding citizen, and if law enforcement comes to your home and they want to speak to your son or daughter or both of them, that it's okay, that there's nothing wrong with that. It's okay. You want your son and daughter the truth. And in most contexts, being a parent myself, obviously we want our children to tell the truth. But in this case, in a situation where your juvenile, your son or daughter, is under 18 years old and they are being investigated or actually being arrested for a crime, any crime, it's against your child's interest to provide a statement to the police. And we recommend that they invoke their constitutional Fifth Amendment right to against self-incrimination. Basically, you invoke your Miranda rights. And some of the factors, particularly if we dig into the weeds a little bit on this issue, is that when they seek to interview kids, well, the question is, well, what happens if the parent's not there, or do they need to contact the parents? Well, the answer is yes. There was a case out of the Florida Supreme Court, which basically says that there's certain factors in determining whether a child's statement to the police is voluntary and therefore should be held admissible in court. One of the main factors is, was the parent contacted or guardian contacted, or was there even an attempt? What was the manner in which they being the police, seek to interview, or how did they interview the juvenile? Were they trying to trick them into an answer? That therefore could be an involuntary statement, an involuntary admission, and that could be held inadmissible. Also, was there a written acknowledgement of a waiver of your Miranda rights? Oftentimes, police will just state Miranda rights. For example, they'll interview a juvenile or a child, say you have the right to remain silent, you have the right to an attorney, but they'll do it verbally and in a fast manner. The proper way to do it is to provide a Miranda form where a child or a juvenile or an adult can actually read for him or herself the actual rights that they may be waiving, so that they are informed of what their constitutional rights are, their Fifth Amendment constitutional rights. But these are all important factors. And that's why when a parent comes to me and they say, my son or daughter is being investigated, the sheriff or local law enforcement wants to interview my son, should we do it? The answer is no. Even if your son didn't do anything or your daughter didn't do anything and you don't suspect that they did and everything, you've got to protect them. And I know it's hard, particularly being a parent myself, because we all want our kids to tell the truth. But at the same time, when an individual, whether it's an adult or a child or a juvenile, is being investigated for a crime, you've got to protect their interests. And you don't want them saying something that could be used against them in court, and I've seen it happen, where it can be misconstrued as an admission of guilt. We don't want that. And that's why it's really important that, number one, that we all know that juveniles have constitutional rights as well, Fifth Amendment constitutional rights, number one. And number two, they actually have there are additional factors when law enforcement seeks to interview a juvenile. For example, like we discussed, was a parent or legal guardian contacted prior to doing the interview, that they have and that law enforcement must follow. So that's why it's important to contact an experienced defense firm like us at Stechschulte Nell. And actually myself, when I first started as a prosecutor, as a former prosecutor, I actually was a juvenile prosecutor working in the juvenile court system. So we saw these issues all the time. And you realize now as a defense attorney how important it is that your parents know their legal rights so that they can tell their kids in the event that, God forbid, their daughter or son is being investigated for a crime. Thank you.